I guess I don't understand why, even if you're right that there's some sort of an issue exhaustion requirement here, that wasn't met in these circumstances. I mean, isn't the issue on appeal whether the presumption of future persecution was rebutted, and wasn't that what the agency was deciding?
So petitioner brought two claims. Petitioner brought, when she went to the Court of Appeals. One claim was that. One claim was about the substance of the decision below and whether she had, in fact, was entitled to withholding. But one claim was about an impermissible fact-finding claim, that the board had violated its own regulations by doing a fact-finding when it adjudicated her appeal.
But the fact-finding was to an end. I mean, wasn't the ultimate issue is whether the presumption of future persecution was rebutted, and there were facts that that the fact finder looks at to make that determination. And so to the extent the board disagreed, they looked at other facts, that's really all part of the same issue, isn't it?
The issues here are certainly related, but I think there's a big difference between saying that the procedural objection to what the board did, right, violating the board's own regulations, versus the substantive determination. Did the board correctly or incorrectly find that she was entitled to withholding or that the presumption had been rebutted? That's a separate claim and a separate question.
And as an administrative matter, sort of administrability, your suggestion is that a person would have to figure out, parse it that narrowly to determine whether or not they had to make a motion for reconsideration as a jurisdictional matter related to the issue, to that issue, but not that one?
Issue exhaustion across administrative context requires parsing. I mean, for instance, I think a couple years ago in Ramirez versus Collier in the PLRA context, the court looked to whether the prisoner had raised the audible prayer claim as opposed to just a regular prayer claim. You are looking to what sort of issues and arguments have been brought up to this point. But I think to the extent you're worried about confusion, this has come up, as I mentioned earlier, in the impermissible fact-finding context, because what the non-citizen is trying to do is add a claim that's a procedural claim in addition to her substantive claim, and that claim is a claim that the board introduced a new error. So that is where the
So what
Courts of
about
Appeals—
Justice Gorsuch's previous question to other counsel? How many times do we have to have reconsideration? Like, what if the board introduces a new error in the context of this motion for reconsideration? Does this go on ad infinitum in your view?
I think that's the beauty of the as of right language. It only allows for one motion to reconsider because that's what you're allowed under the statute and the regulation.